I'm going to give you the option. Do you have any idea about how long you're going to speak?
My opening statement's not going to be very long, so I don't know if there'll be questions.
Okay, well, let's go ahead then. You would identify yourself and who you represent and proceed with your testimony.
I am Judge Mike Wood. I am the judge of Harris County Probate Court number 2, and that is the court in which I think all 3 cases have been mentioned to you today are pending, and I'm not going to talk about them at all because it would be improper for me to do so. I was outside. I didn't listen to anything said because it would be improper for me to hear an ex parte communication by a party to a case, so I was waiting outside. I've been the judge of Probate Court number 2 for 13 years. I've been a lawyer for 33 years, I guess. And I am now on the Executive Committee of the National College of Probate Judges, which is a group that is dedicated to improving probate and guardianship law around the country. I want to give you a little bit of background about the size of the probate business, if you will, in Harris County. It's bigger than most other places in the world. There are 4 probate courts in Harris County. Each of us have a staff of 10 people to assist us in doing our job. 30% of the cases filed in Harris County are filed in probate court number 2, and also 30% court 1. Court 3 and 4 only get 20% because they do the mental health docket. Right now I have about 2,700 cases pending in my court. That's 1,200 guardianships, some of which go on for years and years, some of which are fairly short. I have 1,500 decedents estates pending at any given time. Some of them last 90 days and are closed, some of them last years, but they probably roll over enough that there are probably 4,000 new probate cases each year, so that gives you an idea of the size of the business. Years ago, a couple of years after I was appointed in '95, I had the staff total the assets and the inventories that were filed for my approval for 1 quarter, and then they did it again 5 years later. Both times it was about $750 million. That's just the assets and the inventories, not necessarily the estates that I was really supervising. Most of them are independent estates. But my court, Court 1, are probably among the busiest probate courts in the nation as far as the amount of business that we handle, the number of cases that we handle. The job of a probate court under Texas law is fairly simple. We supervise the administration of decedents' estates and guardianships. 98% of what I do, 95%, is assist parties in uncontested cases to comply with the probate code. And incidentally, I want to compliment the legislature. I don't know if any of you were here when the probate code was originally passed, but it is among the best in the nation. It is a very good, comprehensive, detailed code. It allows citizens to freely dispose of their property without court interference at a very low cost. The filing fee for a probate case in Harris County is about $250, less than $250. And it can be opened and closed in 90 days. If it's not a taxable estate with a state tax return, the attorney's fee shouldn't be too much. I heard recently that to file a will for probate in California costs $46,000. And it took a year and a half minimum, and the attorney's fees were another $10,000 during that. That's just a will, not a contested case, just to file.
Surely you misspoke. $46,000 to file a will for probate?
You remember Proposition 13, Senator?
Of course.
No increase in property taxes, so everything is pay as you go out there. So they have to pay for everything with filing fees. So it's ridiculous. It's just ridiculous. Just to file an equivalent of a minimum title, I really don't have, but to get a $10,000 or $100,000 CD passed down to the next person, the beneficiary, costs $10,000 filing fee. That's just outrageous. So it's very expensive in other places. The other thing the Texas Probate Code does is provide a comprehensive supervision of guardians and administrators that we appoint. Among the best in the country. There's some states where the first inventory is not filed for a year, and there's never an accounting file. I couldn't live in a world where I was appointing somebody, giving them power over someone else's property, and I couldn't even tell what they were doing. We make a lot of appointments, and I want to just run down the list of all the different kinds of people we appoint, just so the committee would be familiar with it.
Judge, if I could, what I'd like to do, I've tried all morning to keep people kind of on message and what our charge is, and what we're interested in hearing from you and everybody else that appears before us today is examine and make recommendations to improve court oversight of fiduciaries appointed to make financial and personal decisions for wards, as well as those appointed to administer an estate or trust. So if you've got suggestions or recommendations for the consideration by this committee in that area, that's what we want to hear. We're not really interested in hearing who all you appoint.
Okay. We supervise very well now. There are issues concerning who I select and who I appoint. It's my choice who I appoint. And right now I have almost 200 people on the list of appointees. Some I appoint in very simple cases. Some I appoint in more complicated cases. And there's really no way for anybody to supervise that above me except an appellate court and the Judicial Conduct Commission. And that's working quite well. If I do something wrong in the appointment of a guardian or administrator, then and if somebody objects to it and I overrule the objection, they can appeal it. If they think I'm really doing bad and it's not a case that they're involved in, they can file a complaint with the Conduct Commission and they'll look into it. I don't know what additional supervision there could be. I've heard suggestions, well, maybe we ought to have an ombudsman to look at the inventories that you approve or the accountings that you approve and see if they're okay. Who's going to pay the ombudsman? If I have an estate that's been pending for 10 years and somebody's complaining about the accountings that have been filed for 10 years, who's going to pay the fees for that person to come in and look at everything and see if it's okay? I have a staff attorney who reviews every attorney's fee application before I look at it. I've written guidelines as Judge Herman does. I provide, there can be no block billings. You're familiar with block billing. It's got the date, it's got a paragraph, and then $1,250. I don't allow that. It's got to have the date, the thing that was done, the amount of time that it took to do it, and the amount of fee. So I can very easily go down and review the fees for individual things, decide whether they're reasonable and necessary, which I'm charged to do.
Let me ask you, if I may, Judge Herman suggested changing Section 666 to include this one sentence. In calculating reasonable attorney's fees, the court shall award fees only for the performance of legal services. Is that a proposed improvement in your judgment?
No, I don't think so. I don't approve attorney's fees except for attorney's work. That's why I have to have it individualized so I can tell. If an attorney takes the ward to the doctor, they can charge a fee for that time, but it's not going to be $250 an hour, their attorney's fee. And I tell people that want to get into the business of being a guardian, you need to have a staff that you can charge out at $40 and $50 an hour for the bottom line stuff. People get to probate court not really planning to. You have a big estate, a guy that's an independent oil man becomes incapacitated. I had to appoint a trust officer from a bank to be the guardian. It took him 3 years and hundreds of thousands of dollars in fees to reduce that man's estate to cash so he could survive on it, because we couldn't, as guardian, operate the oil business. If people plan, the probate code allows them to avoid the fees. I also don't agree with the idea that we should have a hearing on every fee application for over $5,000. The fee application has to be verified. In my case, it has to be detailed. What are they going to do at the hearing? If I set a hearing on every fee application over $5,000, I'd have to have a day a week doing nothing but having lawyers come in and say, well, read the fee application to me. I've already reviewed it and it's verified. So there's really nothing. Now, if somebody objects to a fee, we have a hearing.
Okay, let me ask you this, because I think you've answered the question in a way that you agree with this proposal, but you said you didn't agree with the proposal.
I don't agree with it because I'm not sure what the definition of legal services is. If a lawyer
you're clearly not going to the bank and closing an account.
Except that if you're a guardian and you're a lawyer and you go to the bank to close the account and open a guardian account, you have to do it. If a paralegal shows up, they won't do it. You have to be there. And then the bank says, well, I need to see the whole file. I need to send the file to my legal staff in Columbus, Ohio, or we can't, these letters of guardianship are not enough. So you're there 3 hours or so debating with increasingly high levels of people in the bank just to close the account as guardian and open a guardianship account. So that's why I'm concerned about saying only legal services. I'm not sure exactly what that is. I look at everything that's on the bill, And I decide, well, why, we ask them, why is this 5 hours for this? And that's what my discretion's all about. And if I'm abusing my discretion, there are ways to take care of that. I'm concerned about legislation that tries to define what's appropriate and what's not appropriate, because then you get a longer and longer definition, and you have more and more cases interpreting the definition. The one thing I'll say about contested cases, there's always a winner and a loser, and I have the benefit that the legislature doesn't necessarily have, that I can't hear a case unless everybody is present before me. I can't consider anything unless everybody's here. That's why I wasn't here before when they were speaking. As long as parties have money, there are lawyers who will take the money to fight the fight. I try to limit it as much as possible. When people are coming in, mom's becoming incapacitated, and they're fighting over who's going to be guardian of a mom, I point out to them right at the beginning, I have the discretion whether or not to pay your attorney's fees out of mom's money for you to fight over who gets to be guardian over mom's money. And I'm disinclined to do that. So understand that your fight over this is going to be at your nickel. And you know what? I've only tried less than 5 contested guardianship cases over just that issue in 13 years. It's no fun when you can't spend mom's money fighting over mom's money. There are ways that judges can limit the attorney's fees. As soon as I know about a contested case, I call them in, we have a scheduling conference, I set it for trial, so that they know they're going to have to get ready for trial and the issues that are in the case. And we can't just keep on pushing things around and filing pleadings. But good lawyers file pleadings. Those pleadings have to be reviewed by my staff, they have to be reviewed by me, they have to be responded to, and on and on and on. It costs money. And I can't say, okay, you can't file anything else. That's not something I can do. So I've ruled, they appeal. Well, first they file a motion for hearing because I was obviously mistaken, and then I rule again, and they appeal. And the appellate court agrees with me, and then I do the same thing a year later, approve a similar thing, then they say no. They come in, ask for a motion for rehearing, denied, appeal. The appellate court says, read the last opinion. And they do that over and over again. That is costing this estate money. I can't keep them from doing that. And so that's the problem. And when we hear about exorbitant fees, oftentimes they're not caused by the court. They're caused by the fact that parties are represented by counsel and file pleadings that have to be dealt with. And it takes a lot of time, a lot of court time, a lot of appellate court time. And I don't want to stop people from being able to do that, because sometimes there's a germ of truth. It's especially hard when it's an incapacitated, it's a person who doesn't have a lawyer, they're in there pro se, and they keep on saying the same thing over and over again. You start listening and you say, we need to check into that. And then I might have to appoint somebody to check into it. You might find out that that person is right. There was a problem in that estate. So I don't want to come in here and say, with all these people that are talked to you for the last hour that are angry with me, that there's nothing wrong. There may be something wrong. In those cases, I may have made a bad decision, and there are appellate courts to decide that, and they will make their decision, and I'll abide by it. But I don't think the legislature can fine-tune my discretion without damaging everybody's opportunity to function under the probate code. It is a great code. The amendment that was done, I came on the bench effective a week before the new guardianship provisions came in. And they are very comprehensive and they're very good. They protect the proposed ward very well, and they also allow me the power to protect the ward, to require accountings and require detailed information. So I'm not going to say there's no changes, but the ones I've heard so far, I don't think are necessary. You need good judges to do their jobs, and if they're not doing their jobs, they ought to be removed, either by the voters or by the Conduct Commission.
Mr. Chairman. Judge, I've got just a few questions for you. I understand you to say that you don't want to see the legislature limit your ability to award fees. But the question comes, what do you do about the judge, the probate judge, who refers out services to friends, to acquaintances, to former law partners or former law firms? And not just in small amounts, but in substantial amounts. And we seem to have growing testimony that that's a practice. It might, in fact, be a practice that you engage in.
Well,
What do you do about that?
one case is in the court here and was talked about here. I left that firm in 1986